My name is Ravi. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the fourth part of a six-part series on confessions. Previously, we looked at how competing factors could play a part in deciding whether to admit the confession and or possibly the material that may have been established. Here we are going to expand that further, and we start off by asking the question, what is the view with regard to off the record conversations? It depends on how certain things have taken place. It is important to understand the context in which it came to light. There is no rule of law to prevent an off-the-record conversation being admitted. It is not a complete prohibition. It can be done. But the courts tend to treat, if it is unfairly obtained, it is unfair to admit such conversations. The two authorities that would go to establishing this point would be Okafa and Biederstein. First, let's look at Stephen Okafor. This concerned the importation of drugs into the country. A man was stopped at customs and he consented to a body search. And at no time he was told his right to have a solicitor, or he was given the caution. No, the questions and answers were contemporaneously recorded. Eventually he was arrested and interviewed with the usual safeguards that is available to him in an interview. And the defense made an application to exclude the evidence that took place in the discussion. But the judge rejected that and found that it would not be unfairly prejudicial to him. He was convicted and he appealed. The Court of Appeal dismissed his appeal. Remember, he had a conversation at the customs office, then subsequently an interview. At the customs office, they found the drugs. The defense wants to exclude that part of the evidence. Okay. Even if there has been a breach, which the judge accepted, the next question is for the judge to consider, would it cause unfairness in the proceedings? It wouldn't, would it? Because the drug was found there. So with or without what he has to say, the drugs is there. Yes, it is true. If I recall correctly, he did say that it is he who packed the bag and that he was basically responsible for what is in there. But nonetheless, the appellant could not have come over the problem of finding the drugs there. So where is the unfairness in that? Yes, You might now think of the case where we looked at in the previous part, where the custody officer said, put the drugs on the table, because he knew what the defendant was on police bail for. Now that is very different to this. This is why I said you got to learn your brief inside out and make the distinctions. Now, this is highlighted in the next authority of Einstein. Here, a 40-foot trailer came to the UK from Zeebrugge to one of the ports, and that was intercepted. The lorry driver spoke fairly good English. He had legitimate items in the cab, but there was a whole load of cannabis in the trailer. He had a conversation with the customs officer. I have the authority here. And basically, the customs officers wanted him to provide more information to secure those who are also established in this enterprise. And there came a point when that particular customs officer left the area to do some work on this matter, whilst the second customs officer came and sat with him, and a conversation started. And the customs officer was asked that if he knows how many kilos that they have found. And this second customs officer says, I don't know. Then he went on to ask how much should have been there. The lorry driver replied, 40 pallets or boxes, and part of it is to be dropped off at Heston. He was asked whether he should be contacting anyone, or does he know where he to go. Basically, he said, I've been told to go to Heston, but I had to ring my boss. Then he was allowed to take that route, and eventually the prosecution took place. The defense wanted to exclude all of that material, and the judge refused. He was convicted and he appealed. Here, the Court of Appeal did find that the customs officers' actions breached the rules because there was no record of what was discussed and that he was given the opportunity to sign. Equally, he was asked as to what he was to do and the procedure in which that he was going to follow. Consequently, the court found in favor of the appellant. Next authority that I would consider is, in fact, it is important to note here there is a contrast between Okafor and Einstein. Here the Court of Appeal had no hesitation in saying that the lorry driver was not given the notes to sign There is no record that was made immediately because it was made several hours later and he was not given the opportunity. Therefore, the integrity and the way in which it has taken place gave concern, and the appeal was allowed. Next that I would consider is self-confessions, where one would regard self-confessions to be a problem at times. Therefore, the question to ask, is there a difference between a self-confession and a confession made to an informant planted by the police? Remember that we looked at the case of Allen, how that transpired, the breaches of human rights issues and the like. I'm not going to dwell on that because we have covered the case. So all what I will say is the issue of whether self-confessions as opposed to an informant planted by the police is admissible or not depends on the circumstances. Remember, taking the holistic view in these cases. Next that I would consider is by asking, in the light of the case of Allen, how does the courts deal with cases involving subterfuge? The answer is, you got to look at subterfuge as agents of the state, and the authority that I would rely on is a case by the name of Christopher Rowland Nudge. This involved a murder allegation. The body was never recovered. The entire case basically relied on self-confessions made by the appellant to his cellmate, who was a despicable man with several convictions, and the police, the prosecution, relied on him. When the appellant was in custody, in prison, he was put into a cell with the informant by the name of, he was put into a cell with the particular informant. It was not arranged by the police or the prisons. It just so happened they were in the same cell. Not long after they were in the same cell, the appellant began to talk about the death and gave graphic details how the murder took place, how he took the body in parts to an incinerator for incinerating animal carcasses, what he did with the murder weapons. Over a period of time, the informant gave statements to the police. The police, in fact, gave him very specific instructions not to induce, not to basically beat out a confession out of the man. Can you remember an authority that we looked at earlier, where in that situation where the police had told the informant, get what you can? Here it was the contrary. the police gave written instructions not to do anything of that nature. And nonetheless, there may have been some breaches on the part of the informant, despite what he was told, which is, you must not start any conversation with Nudge about the investigation into Frederick Moss or ask him any questions about what he says. So he was given very clear instructions. Dribs and drabs information came out, and this man was giving all the information to the police. Yes, he had once asked if he can appeal or have his conviction reviewed, but the police have not made any promises or anything. And there has been some written notes between the informant and Nudge. At trial, the defense sought to exclude the entire discussion between Nudge and the informant. One of the arguments was that when the police were told initially by the informant that Nudge is making admissions, giving details, that they should have been separated and isolated from each other, by putting Nudge back with this informant constituted basically subterfuge situation. Therefore, it should be excluded. The Court of Appeal took a very different view to that submission. The Court of Appeal took the view that they were on equal terms. It was not designed by the police, the prosecution, or the prison authorities deliberately to put them together. It just that so happened that they were together. So they were on equal terms. Yes, it is true, the informant is not a pleasant man. He has a string of convictions, and there is a reputation that he is unreliable too. Yet, the Court of Appeal dismissed the appeal from this particular appellant, Nudge, because he was never a state agent. He was not deliberately planted there. He just happened to be there. They were on equal terms. And even when he went back to the same cell with Nudge, he was even told, do not prompt answers from this man. So there was no impropriety on the part of the police or the prosecution. Therefore, the court was unable to find a reason to reject what the informant said. But as to the weight of the evidence, it is a matter for the jury. And the Court of Appeal agreed with the learned judge's findings and acknowledged that the informant is an unpleasant man. This is one of the paragraphs. In fact, I'll refer to paragraph 27 and 30. Thus, when the applicant first confessed, the two men were sharing the cell by chance. They were equals, and the applicant was under no pressure. This is not a case where, having maintained his right to silence, he was pressurized into revealing all. Remember the young boy with educational disabilities, Delaney, that is different to this. Secondly, paragraph 30. From everything that the applicant has said and from what Mr. Horner, thus the informant, has said, and the general tenor of their correspondence indicates two equals sparring with each other and exploring a possible future relationship. There is no hint in the notes of the applicant feeling under any undue or improper pressure. So it all depends on how the facts have come about. If it was the part of the police ingenuity to adduce such material, then yes, there may be an argument. The next case is, very briefly I will touch upon, is Lawrence Jelen and Anthony Katz. This is basically an entrapment style securing evidence. Here the important point is that it all depends on the facts of the case, which I have been saying right from the outset. Therefore, it is important to understand your brief and apply the situation to consider in the light of these authorities. No case is the same as another one, and it is important to understand the circumstances in which the discretion could be used could vary from case to case. Even from judges may take different views. Next, I'm going to ask myself, can the facts found as a result of an inadmissible confession be excluded? It depends on various factors. And one of the things that will impact is whether it's a Section 76 or 78 application. Because Section 78, as we know, gives a general discretion where it is unfair to admit such and would have such an adverse effect on the fairnessness of the proceedings. They are the key words. Whereas Section 76 refers to this. Look at Section 76, subsection 4, 5, and 6. Subsection 4 reads, the fact that a confession is wholly or partly excluded in pursuance of this section shall not affect the admissibility in evidence. A. Any facts discovered as a result of the confession. So any facts, i.e. material. Be a knife, be the drugs, whatever. B. Where the confession is relevant as showing that the accused speaks, writes, or expresses himself in a particular way of so much of the confession as is necessary to show that he does so. In other words, if a person uses particular phrases or an accent, that is, in order to prove that, basically the identity, that may be possible. Subsection 5. The evidence that a fact to which this subsection applies was discovered as a result of A. Statement made by an accused person shall not be admissible unless the evidence of how it was discovered is given by him or on his behalf. In other words, even if the evidence is admitted, you don't refer to the confession, unless, of course, the defendant, he himself introduces it in evidence. That is why it says, the evidence that a fact to which this subsection applies was discovered as a result of a statement made by an accused person shall not be admissible, unless evidence of how it was discovered is given by or on his behalf. In other words, you can lose your shield if that, to put it colloquially, and put it in. Subsection 5 reads as follows. A. Any fact discovered as a result of a confession which is wholly excluded in pursuance of this section. And B. Any fact discovered as a result of a confession which is partly so excluded if the fact is discovered as a result of the excluded part of the confession. So it goes on to elaborate. Next question that I would ask is, what is the effect of section 76 base? Depending on the circumstances, of course, any fact that is found can be admissible. What it cannot do, as we learned, to introduce the confession. However, there are limitations to this. So let's ask ourselves, what are the limitations on exclusion? Answer. The exclusion only applies to facts found under section 76, but not to the confession under section 78. What it is interested to note is, whilst the courts are allowed to say this material was found, the court is not being told why or how that material came to be known. That is in order to distance the defendant between the material found and the confession. Otherwise, what you do is you link the two together. And this is particularly comes to light when we consider the case of Lam Wei Ming. So let's consider the next question, which is, how about where it is not clear? As I said, now let's look at the case of Lam Wei Ming. The case involved a murder. A young girl was raped. She told her family, the two brothers and her boyfriend met the deceased at a club or somewhere, and the following day he was found with stab wounds, and it was established that the murder took place between 2 o'clock in the morning and 4:30 in the morning. The defendants were arrested. If I recall correctly, the allegation was denied initially. However, the first defendant led the police, having taken the police to where they discarded the murder weapon and identified, dropped it there into the water, into the sea. The other defendants were there, and they were charged. One of the things that you would remember is that a statement need not be made in words. Gesticulation could stand as a statement. So pointing the place where they dropped the knife is sufficient enough. This case was a case from Hong Kong and went to the Privy Council, having been convicted, and the Hong Kong Court of Appeal having rejected the appeal. The Privy Council allowed the appeal in because pointing where the murder weapon is actually to admit the confession, without which they would not have known. So therefore, in essence, putting the murder weapon from where they recovered it is to admit their confession. This is the decision of the court held, allowing the appeal that the evidence with regard to the conduct of the defendants which led to the recovery of the murder weapon was part of their confession to the police. And although the evidence had been shown to be reliable by the discovery of the knife, since the prosecution had failed to prove that the confession was voluntary, the whole evidence relating thereto was inadmissible, and that therefore the judge had erred in admitting in evidence the silent video recording and the police evidence relation to the conduct. What the Court of Appeal basically failed to understand in Hong Kong, and the Privy Council saying is here, although it was a silent video, what they are doing by pointing the finger where the murder weapon was recovered from is an interview, is a confession. And in the absence of evidence to show that it was done voluntarily, it was not going to go anywhere. And the appeal was allowed. Consequently, you would note that in order to understand whether confession will be allowed or whether the material that is recovered will be allowed as evidence depends largely on the facts of each case. Even if, in order to wind off, let's wrap it up in this manner. Even if it was improperly obtained, or there are breaches, like in Kofod case where the drugs were recovered in a suitcase, so what? Or in the case of Khan and Sultan, so what? Bugging the house, bit of criminal damage to the property, as opposed to the case of Delaney, or the case where the murder investigation of Nubs. So you look at all the circumstances. I hope you have found this part of the program useful. That is all I intend to cover at this stage, and we will consider the remaining two parts in quick succession. Thank you for your valuable time. I hope that you will join me soon. God bless.